Good morning, colleagues. We're going to start in 5 minutes. Thank you. Colleagues, thank you for joining. I'm testing the sound. If you can hear my voice because you're all muted, can I see the thumbs up before we start? Thank you so much. Good morning, stakeholders and colleagues. Welcome to today's webinar. We've been attending these webinars, I think, for the past 3 weeks on a weekly basis. I promise you next week we'll take a break before we tackle another topic. Thank you so much for taking your time and joining us this morning. I know it's a Friday, but we're going to have a participation that is not too formal because the purpose is to educate and bring awareness. We want to participate and engage with you, so all the questions will be welcomed. We wanted to focus on two important topics that have a direct impact on property practitioners and as well as consumers. The Housing Consumer Protection Act 2024 and the PPRA Mediation and Dispute Resolution. We know as property practitioners, it's important for us to understand your rights. For some of you who've been reading our legislation, if you can draw attention to Section 69 of the PPA, it says we have to educate on the code of conduct, on your rights, your legal obligations. So these sessions are legislated, colleagues. And today's session, we wanted to focus, especially coming from PPRA, the Section 28, especially for those who received complaints against them, your firm, your interns, as you have seen on the email when I posed the question. So Section 28 will focus on, investigations. When you are being investigated as a property practitioner, you shouldn't be scared. What does it mean? So I think our first speaker coming from PPRA will also touch on that Section 29 on the processes of handling the complaints. And we also wanted to touch on Section 30, when your matter goes for disciplinary hearing. And when we say we have jurisdictions, what kind of matters are we looking at? And our second speaker, we wanted to tackle, coming from NHBRC, Section 81. I know in her presentation, she will talk about the mandate, but I think she will go deep into Section 81, especially duties of property practitioners, just to outline, what is required from your side as a professional in respect to the responsibilities of yourself as an estate agency. And I think they will highlight some of those topics. I'm going to go through the housekeeping rules before we begin. We are going to mute everyone. Everyone is muted. We are not going to recognize the hands now. We see your hands. We're going to allow the speakers to present. Once they've presented, we will engage on the questions. We'll unmute you after they've presented. And all your questions, you can put them on the Q&A and on the chat, and we will address them. If you have a reference number regarding the complaints, you can also share on the chat with the email address, and we will give you the status of the complaint maybe after the webinar. And we're going to tackle all the questions up until 12 o'clock. So who is our speakers today? Maybe you ask. Our first speaker is Ms. Delin Kambule. She is the Investigations, Mediation, and Adjudication Manager here at the PPRA. Deli is an admitted attorney currently working in the legal department. In 2013, she was appointed as a legal manager in that act of EAB, but now the roles have changed with the titles. We call them IMAs now. In 2019 to March 2022, she was appointed acting as executive manager of enforcement. And in 2022, April, she acted as the acting CEO of the PPRA when that act was introduced at the time. And she also acted as the COO, and she also acted as a transformation manager and the claims manager. She serves as a board member at Tshwane School of Business and Society. She started there as a board member in 2023. She holds a diploma in drafting of contracts. So she does specialize in contracts, the BA law degree, LLB, and MBA, which is a Master of Business Administration. She's also a developer in her capacity, so she's passionate about the sector. And our second speaker is Ms. Nkadisha Rasebotsa. She is a legal advisor from NHBRC. Ms. Rasebotsa is an admitted attorney, a conveyancer, a legal advisor who brings specialized expertise to the South African property and regulatory sector. She currently serves as a legal advisor within the NHBRC corporate legal team, where she is responsible for legislative review, advisory services, and reviewing staff decisions regarding home enrollments, non-compliance, and warranty claims. Prior to her experience, she also worked in the private sector, and she's been assisting clients for many years in the legal entity and related to township establishment development and matters relating to national building regulations and building standards. And I think the important thing as well to know is that she holds a master's in property law, having authored a dissertation on the impact of the South African negative deeds registration system on registered titles to immovable properties and remedies for underlying title defects. And I think it was important for me to mention that because, we want experts who are going to be able to answer your questions, no matter how technical they are when it comes to Q&A sessions. And Ms. Rasebotsa, she's not alone. In the panel discussion of the Q&A today coming from NHBRC, she is joined by her colleagues, Mr. Hulisani Mbara. He is the Manager, Regulatory and Enforcement in that unit, who will also assist in the Q&A, and also in that panel session for Q&A, she will be joined coming from NHBRC, Mr. Ezekiel Mhlongo. He's also a manager in the unit of corporate legal. So they're going to engage as colleagues. Let's ask them anything related to the topics once they are done. So let me go straight now to our first speaker, Ms. Delinga Mbule. You may share. I'm going to stop flagging the social media handles. Colleagues, please remember to follow us. Ms. Delinga Mbule, you can flag your presentation so we may begin. Thank you.
Thank you, Naledi. You'll tell me once you're able to see so that I can start.
Yes, we can see it. You put it on slide mode.
Slide mode.
It's still loading. Yes, it's now on slide mode. Thank you.
Okay. Good morning, colleagues, and good morning, everyone. And thank you for the opportunity to present to you our dispute resolution process within the investigations department. So if I were to ask you to picture a legal dispute, I think most of you would probably picture a courtroom with expensive advocates around, piles of documents or paperwork as evidence, in a process that we know it takes long, it takes months, and sometimes it can drag for years. But it's important to say that court is not the only path to justice. In fact, it should be the last resort, especially for us in this space, because we have a regulatory body that can assist with resolving dispute. So today's presentation, colleagues, is a recap of our dispute resolution process. We have presented it before, but that's why I'm saying it's a recap to our dispute resolution process, which process can save time and money for both consumers, property practitioners, as well as firms. So the Property Practitioners Act, unlike the Estate Agency Act, it introduced what we can term a robust and a comprehensive, as well as a simplified framework for dispute resolution. In fact, the framework, colleagues, introduced a mechanism where consumers are assisted to find common ground to issues that they have. They are assisted to resolving disputes harmoniously, such that even after the resolution of the disputes, the colleagues can still, or the parties can still work together in the future. What I've spoken about, or this mandate that I'm speaking about, can be found in section 29, 30 to 31. So if you would like to read more, then you can go through that section. So what we are saying is that at the heart of, or central to the framework that created dispute resolution is the department within the PPRA, which is called the Investigations, Mediations and Adjudications Department, known as IMA. This unit or department is composed of an in-house machinery specializing in processing consumer complaints, and also what we now call inter-property practitioner complaints. The unit is composed of 5 dedicated attorneys with support staff, which are tasked with the responsibility of then navigating the investigation of consumer complaints. So our dispute resolution process follows a pathway that is stipulated in the legislation. This is the pathway by which complaints should be investigated, and I will cover this in detail in the next slides. But here, I just want to give a quick high-level overview of the pathway. So it starts first with the lodging of a complaint. A consumer must lodge a complaint, and this complaint must be completed or lodged on our complaint initiation form. And the process of lodging it can either be manual, which means you complete the form and email it to us or deliver to us, or you can go online and complete the form. Then we move over to the second process, where once we have received your complaint, we will then, as the IMA unit, review and register your complaint. And we are then supposed to, within 14 days, business days, acknowledge that complaint. The third process then involves the determination of whether this matter can then go to mediation. And we are saying mediation is voluntary because the parties have to consent to go to mediation. And at the end of the mediation, we then issue what we call a certificate of outcome if the matter is settled. The next process, which is a more formal process, is the adjudication process. And this usually happens where the parties have not been able to resolve their issues at mediation. It's also applicable where the complaint that has been submitted is of such a nature that it cannot be resolved by mediation, because there are complaints that cannot be mediated upon. Also, when you read section 28, where we've served you with a compliance notice and you fail to respond to the compliance notice, then this matter can also go to adjudication. So there are 3 ways in which we can have matters go or land up in adjudication. Then when we get to adjudication, if you're not happy with the decision, we've got the next forum, which is the Adjudications Appeals Committee. And any person who is not satisfied with the decision of the adjudicator can then move forward to place their matter or to lodge an appeal. So basically, colleagues, because our act is consumer focused, we find that in section 28, a consumer is then given the power to lodge a complaint. So any person who is negatively affected by the conduct of a property practitioner, or any person who is unhappy with how a property practitioner has treated them, then they have an opportunity to complete a complaint against the property practitioner. So colleagues, you see, that we really need to make sure that we keep our clients happy. We know that clients can complain, but I think it is our responsibility to make them happy. However, we must do that without compromising our rights to earn a commission, because we are in this industry to earn a commission. And also, we must not compromise our principles. We know we have a code of conduct and we have an act which we must then comply with. So, as stated before, the complaint can be submitted either online, it can be emailed, and if you are able, you can hand deliver the complaint to us at the PPRA. And once the complaint has been submitted, then what we then do is we assess whether we have jurisdiction to entertain the complaint. And jurisdiction basically means that we determine whether the issues that are complained of are issues that fall within the mandate of the PPRA, are issues that we can apply the code of conduct and say, this is the particular code of conduct or provision of the act that can be applied. So I know that consumers think that we can do anything, and especially when they're aggrieved by a property practitioner. But it's important to note that because our organization is established by law, we are bound by specific laws and provisions. So this means that there are things that we cannot do, despite the belief of the consumers that we can do anything, and there are things that we can do. So I just want to touch on some of the things that we cannot do, colleagues. This is not an exhaustive list, but it's one of the things, it's some of the things that I just need to highlight. So our responsibility, or what we can do, we are mandated to investigate professional misconduct or a breach of ethics, anything that relates to improper conduct, and sometimes or professional, conflict of interest. We are mandated to investigate whether that conduct is done by a registered property practitioner or an unregistered property practitioner. We are also entitled to mediate disputes. These are disputes between property practitioners. We know that sometimes as colleagues, we have disputes. The Act now empowers us to resolve disputes between property practitioners themselves as well. We can adjudicate on matters, we can prosecute as the IMA department, and fines for non-compliant property practitioners can then be imposed. That's part of the powers of the PPRA. We are also mandated to consider claims against the Fidelity Fund. However, this is only for registered property practitioners. So if you have had your monies been misappropriated by a property practitioner, then when it comes to considering claims, we will not be able to consider that claim. But in terms of investigating an unethical conduct, we've got unlimited jurisdiction. Then I just want to also highlight the things that we cannot do. We cannot interfere in eviction orders. We can't even prevent eviction orders. Also, where there are civil court proceedings going on, we can't interfere in those. It really lies with the courts. There are also issues that relate to sectional titles. There are issues that relate to CISOs. We cannot deliberate on those issues. And it's important that consumers understand that because there was a managing agent involved, we need to assess whether that matter is a contravention of our act or whether that is a contravention of the Sectional Titles Act, and which must be dealt with CISOs. And I know that there is always that confusion where when the consumer fails to get a satisfactory order at the CISOs, they then run to the PPRA, or they want to conflate the issues and have the PPRA and the CISOs both dabbing onto these issues. We need to separate the jurisdictions. We're also not able to resolve employment or labor disputes between your principals and property practitioners, and we are also unable to deliberate on contractual issues or interpret contracts or even enforce those contracts. Let me now move to the first stage of investigating a complaint. So I have stated that once we've received the complaint, our department is then supposed to, first of all, acknowledge that complaint, and this must be done within a period of 14 days. And in that acknowledgement, we're supposed to then include your case reference number, or what we call a reference number. Case reference number is the same thing. And then once we've received that complaint, we do the assessment of whether we have jurisdiction or not. If we find that we do not have jurisdiction, we will then write to you as the consumer and advise. Yes.
Then I see on the chat a lot of people, they're struggling with sound, saying
Yes.
they can't hear the sound. Sound is low. Is your volume on 100%? But I've advised them maybe to log out and try to log in again. Maybe they can refresh. Colleagues,
Naledi, let
can
me
everyone,
see.
colleagues,
My
can you
volume
hear?
is at the highest, Naledi. I'm not sure what about the colleagues, and whether then do they want me to repeat, or they can then go through our recording, Naledi, so that I
Oh,
don't
yes.
delay.
Yeah, I think they will have to log out because I see thumbs up. Most people can hear you.
Okay.
At least I assisted. We can continue. I'll share the recorder. Thank you.
Okay, apologies to those colleagues who can't hear me, but for the sake of progress, I will proceed. I know that this is recorded and we can then go through and listen to the recordings, but I hope that you'll then be able, even if you can't hear me, to be able to use your chat box so that you can ask me questions. So I think I don't know if I'm lost, Naledi. Where was I? I think, no, I need to go back. Sorry, colleagues, just, yeah.
To go back. Yeah.
Yeah,
Thanks.
so once we have determined that we have jurisdiction, because I've covered where we don't have jurisdiction, we will notify you and we'll give you reasons why we believe we don't have jurisdiction. As well, we can also give you advice of which other regulatory body you will or can approach to assist you. Because remember, we are not the only regulatory body that can assist consumers. Sometimes it's just a complaint against a against a landlord. So you must go to the Rental Housing Tribunal. So where we've determined that we have jurisdiction, one of our core pillars is the administration of justice, which basically dictates to us that we must then serve that complaint to the property practitioner and give the property practitioner an opportunity to respond to the complaint in writing. So we cannot ambush a property practitioner with charges. They must first understand what is the complaint and defend themselves. Once they've been given this opportunity, they then are supposed to, within 30 days, respond to us in writing, giving us their reasons, whether they admit or dispute the allegations. Once we have done that, we'll then send their response back to the complainant to notify them of what the agent or the property practitioner has said. And at that point in time, we then await the complainant to also respond back to the agent's comments or the property practitioner's comments. Then we will begin to assess the legal issues that have been raised. So, and the reason why we are able to send this complaint to the property practitioner is that we usually in the complaint ask you to give us the address of the property practitioner. But if you don't have, we as the PPRA have a database of all the registered property practitioners, including their business addresses, and then we can use that address that we have. So the second stage, colleague, is that once we have all the documents that we need, which is even the responses from both parties, we will then determine whether this dispute can be mediated. If we're of the view that this dispute can be mediated, then we ask the parties to come to a mediation so that we can resolve the matter amicably. So the mediation processing is free unless it involves property practitioners. So if there are two property practitioners who have a dispute, especially with commission, then the Act says there will be a fee that is imposed. This process is crucial, that both parties consent to be part of the mediation, because legally we are not, people are not forced to participate in the mediation proceedings. So if the parties agree to mediation, then a mediator is appointed to assist in the mediation process. And key to the mediation process, colleagues, is the confidentiality of the proceeding. So what am I saying? I'm saying that anything that is said, anything that is proposed or done during the mediation is strictly confidential, and it cannot be used as evidence in any subsequent or later court proceedings or adjudication proceedings if the mediation fails. And if the issues are resolved, then colleagues, then the parties are supposed to sign what we call a settlement agreement, and the mediator will then, upon the settlement agreement being signed, issue a certificate of outcome. Then that's where the matter ends, and there is no longer an alternative to proceed. Unless the parties then don't comply with the settlement agreement, then the matter can come back and it will go to adjudication. Also, if the mediation failed, then that process will now move on to the adjudication process, and the mediator will issue a certificate stating that the mediation failed, and we move over to the next process. We move over to the next process. So the third process is the adjudication process, and I've already stated that a matter lands in adjudication if mediation has not been successful. There are also some matters that cannot be mediated from the word go. So if we have a complaint that a property practitioner has misappropriated funds belonging to a consumer, even if the property practitioner pays those monies back, it will only act as mitigating circumstances during argument in adjudication, but the matter will eventually land up at adjudication because an order must be issued. Sometimes, as I've explained earlier, where we've issued a compliance notice to a property practitioner, requesting the property practitioner to comply with the compliance notice, and there's been a failure to comply, then that matter will end up at adjudication. So at adjudication, we then have an adjudicator who is appointed. So we are speaking, when we talk about an adjudicator, we're speaking about a person who is legally qualified, and usually and most of the time, and in fact all the time, it's an advocate or an admitted attorney who is practicing, has his own law firm, is not affiliated to the PPRA, and therefore is an independent person. He's the one that then will act as the adjudicator during the hearing. And the Act empowers the adjudicator to set the matter down for adjudication within 60 days after they have been appointed. And then the EMA department with the support staff is responsible for ensuring that the parties are summoned, the parties are subpoenaed, and most of our adjudications are held virtually. We do hold venue-based adjudications, but that is only on exceptional circumstances, and we need an application and a motivation why the adjudication should be held physically. So if the adjudicator finds that you are guilty, so maybe just to track back, the EMA department, so the department that is responsible for the investigation, for the mediation, has 5 attorneys who are responsible for this investigation process. During the adjudication, these attorneys then act as case presenters on behalf of the consumers, and they act as prosecutors to prosecute on behalf of the consumer. So that's another function of the department other than just the investigation and looking at the documents. During adjudication, Both parties, being the property practitioner as well as the consumer who has complained, are required to be present. They are required to give evidence. Their evidence is on oath, so they have to be sworn on oath and give evidence. And the adjudicator will then be able to ask clarifying questions. He then will issue an order as he deems fit. He can find the property practitioner guilty. He can find the property practitioner not guilty. And in doing that, he can impose the following penalties. So please bear in mind that the penalties are not meant to, they're meant to be a deterrent to the unlawful conduct. So if you're found guilty of unethical conduct or statutory violations, then the adjudicator can impose what we call a compensatory, consumer compensatory award, which is an order that 80% of the fine that is imposed to the property practitioner must then be paid to the consumer as compensation. Another sanction that can be imposed is that as a property practitioner who has a fidelity fund certificate, your fidelity fund certificate can be withdrawn. And if the firm has been charged and is also found guilty, the same sentence can also be imposed, unless the adjudicator is of the decision that different sanctions must be imposed on the property practitioner or on the firm, which is withdraw the property practitioner's FFC and not the firm. Withdraw the firm's FFC, and in any case, then the property practitioner's FFC will be withdrawn. Also, the adjudicator can, as per empowered by the Act, impose any fine that he believes is appropriate in the circumstances. So basically, the adjudicator has to look at the situation and then issue a decision that fits the situation in that particular circumstances. The PPRA can also do what we call a criminal prosecution referral for serious crimes such as fraud. We will then liaise with the SAPS to report that property practitioner. As I stated, once the adjudicator has issued any of those sanctions or remedies that I have stated, and it should be, the adjudication process should be the last process, which should bring the matter to an end. But however, we know that some people will not be happy with the decision of the adjudicator, and they then have an opportunity to appeal. The appeals process becomes the final and last process that you can follow, or to which the PPRA can assist you in resolving a complaint. If you're unhappy with the decision of the adjudicator, you can then appeal through the appeals committee. The appeals committee will also then invite both parties during the appeals proceedings, and they will then issue a decision. Their decision is final, and in fact, it ends the matter within the PPRA. If you're not happy with the decision of the adjudications appeals committee, then your only option lies with the review with our courts, which means then you must take your matter outside and get attorneys to represent you. The IMA and its attorneys will not be able to proceed with you, even if you're a complainant or a respondent. Both parties have a right to appeal. I hope that we have all been able to understand the process of investigating. It's really a process that takes some time and months, but it is convenient, it's cheaper, it's less strenuous, and depending on the complexities of the case, it may take more than 6 months to finalize. Naledi, I think that brings me to the end of my presentation. Thank you, colleagues. For any further information, there are my details, my email address, and my telephone number, and I will be ready to take questions. Thank you, Naledi. Thank you, colleagues.
I'm even okay. I managed to unmute. I was having a challenge to unmute, and I see there's a lot of people in the lobby, and I'm struggling to even accepting them, but I've escalated the matter to our IT. Thank you, Deli, for that presentation. It was informative. Let me welcome our second speaker to flag and give us the presentation, Ms. Ngadisha Rasabodza. Yes, we can see the slides.
Well, thank you, Naledi. Good morning, everyone. Good morning, Naledi. Thank you for affording the NHPRC this opportunity to make a presentation. As I've already been introduced, I'm the legal advisor for the NHPRC. I will be unpacking the Housing Consumer Protection Act, which has really introduced new obligations for property practitioners. And thanks, Naledi, for confirming that you're able to see the screen. Well, by way of introduction, before I can start with the presentation, this piece of legislation that I'll be presenting on, it's really meant to enhance the effectiveness of the NHPRC through the improved enforcement mechanisms and to increase protection to the housing consumers, hence the name, the Housing Consumer Protection Act. So by way of the presentation, in terms of the table of contents, the presentation is outlined as follows. I will deal with the mandate of the NHPRC so that we are all aligned. The legislative framework, the application of the Act and what will be the exclusions, the purpose of the Act, some of the quality control and risk management that are brought by this new legislation, the warranty cover that is provided by the NHPRC, the obligations imposed by Section 81, as Naledi has mentioned, 82 and 83 of the Act, failure by the property practitioner to comply, and the enabling property practitioners, and how will we enable property practitioners to comply with the Housing Consumer Protection Act. So I will start with the mandate of the NHPRC. What is the mandate of the NHPRC? It's to regulate the home building industry. And how do we do so? By registration of home builders and developers. We regulate through the enforcement of the Act, the code of conduct for home builders and developers. And we do so by facilitating risk management. We assess the home builders' performance. At least that is the intention of this new Act, to regulate the home builders' conduct and to promote the minimum standards and best practices within the industry. So we further represent the interest of the housing consumers, which is really our core mandate as the NHPRC. And we do so through the enrollment of homes. And you would note that before we can have a home enrolled, we have to have a home builder that is registered with the NHPRC. So we do so through the enrollment of homes prior to construction. We further represent the interest of housing consumers through inspection of homes during the key critical stages of construction. And that would be prior to commencement of construction. It's quite critical for the NHPRC to inspect, to do pre-inspection before construction, to verify that construction had not commenced. Foundation level, these are still the key critical stages of construction, which NHPRC must inspect: substructure, superstructure, and practical completion. And this is just in the interest of representing, or rather interest of housing consumers and protecting the housing consumers. So we further provide the warranty cover. and we have to ensure, structural quality of enrolled homes. We can only ensure the structural quality of homes only if a home is enrolled with the NHPRC. And we do so through the inspections and still in the interest of housing consumers. And really based on the warranty is not only based on an amount that the NHPRC will utilize to assist housing consumers to rectify defects, but builders are required to rectify defects reported within the prescribed period relating to whether it's maintenance-related defects, which is your snag list, or your roof leak and structural defects as well. So that is the mandate of the NHPRC in a nutshell. So in respect of the legislative framework that regulate the NHPRC, currently we operate or we are regulated by the Housing Consumer Protection Measures Act of 95 of 1998, which came into operation in 1999. So we still very much operate under this piece of legislation. However, this act will be repealed, or it's repealed, let me say it will be repealed once the new law comes into operation. So this new law that I'm presenting today, it's not yet in operation, which is the Housing Consumer Protection Act 25 of 2024. It has been signed into law by the President on the 29th of January 2025. However, in order to operationalize this law, we are still finalizing the regulations and the rules to be able to implement this new piece of legislation. And once the regulations and the rules have been finalized and there've been public engagement, the minister would proclaim the commencement date of this new piece of legislation. So by way of application, this new piece of legislation, Section 2 of the Act provides that this Act applies to new homes, and this would include your timeshares, your share blocks, and the Act makes that quite clear. The additions, alterations, renovations, or repair of a home. However, this application on additions and alteration, it's only applicable in as far as those additions, alterations, or renovations would necessitate the submission of building plans to a municipality in terms of the National Building Regulations and Building Standard Act, your Act 103 of 1977. So the Act does not apply to a dwelling unit that does not have its own bathroom or kitchen, any temporary building as contemplated in Act 103 of 1977, a shack or caravan, any structure forming part of an informal settlement, a hotel or a motel. So these are the part of structures where the Act does not apply. Any other dwelling that has not been specifically excluded in terms of this Act, the Act applies to such kind of dwellings as long as it's a home and regulated within the NHPRC Act. So what is the purpose of this new legislation? The purpose of the Act is to improve the regulation of the home building industry. And in order to achieve that, the Act emphasizes that there has to be an integrated and more comprehensive register of home builders and developers. And this is more detailed in terms of Section 23 to 26 of the Act. So this integrated database, it's really aimed at ensuring that there's reliable information to assess the performance of home builders and developers. There will be a new grading that would be approved by the NHPRC, which would be linked to the registration of a home builder or developer. and also to regulate the builders and developers' conduct and to promote the minimum standards and best practices in the industry. So in addition, this act really expands its application to owner builders, so meaning that we'll no longer have owner builders that apply to the NHBRC for an exemption. This owner builders would, includes persons who builds for themselves, for whatever purpose, who build homes for themselves for whatever purpose, whether it's for sales, leasing, or renting out. So the owner builder part, there will no longer be any exemptions in relation to owner builder. So as already indicated, I have said that the Act expands its application to builders, developers who carry out renovations and alterations, including additions. So in relation to the enrollment, the Act provides that there has to be a register of enrollment of homes in terms of Section 29 of the Act. So this register would be updated continuously in relation to the status of the project. That will be a construction of a home. So every home that is enrolled would have information relating to inspections of that home, any non-compliances that would have been issued and how they've been addressed. This is critical because, during the process of construction, non-compliances can be issued in relation to any part of the structure. You might find that structural defects or serious technical non-compliances that have been identified and that the builder must address such. Sometimes they may even relate to a competent person that would be your engineer, your structural engineer that are responsible for the design. So a lot can happen in respect of non-compliances that are issued and how they are addressed. So it's quite critical. So this information would be aligned to a home that is enrolled and would be recorded by the NHBRC. So the completion of home as well is quite critical to have a record as to the completion of the home, the occupation certificates that would have been issued, the final inspection reports, and obviously they have an impact in terms of the warranty post-occupation. I would also touch on the fact that the new Act provides that the warranty commences from date of construction. And also in respect of claims, if there are any claims, structural defects that have been identified, roof leak defects, and the builder comes to the party to rectify, or they fail to some extent, and the NHBRC provides warranty. So all that information would be linked to an enrolled home. So this is quite important information for the register of enrollments. Still on the purpose of the Act, so the Act provides for the effective manner of dispute resolution process, whether it is a dispute relating to a non-compliance with the Act or technical requirements during construction, the contract disputes between parties to a home building contract. The Act identifies that parties to a home building contract, it's not only your housing consumer or a home builder or developer, but it can be a housing consumer, home builder, certifying body, or a competent person. And these persons have responsibility in respect of, in terms of this Act. So the Act further provides for a shorter and more effective dispute resolution process, as I've said, by providing a provision of a compliance enforcement committee, a CEC, which is a statutory committee that would be dealing with any objections relating to your administrative and substantive non-compliances. This committee somehow replaces the current disciplinary committee of the NHBRC, But this committee has now been elevated to a statutory committee because it's established in terms of the Act. It's not just your council committee. And as I've said, it will be dealing with objections in terms of Section 63 and 64 of the Act. So this committee has the power to impose appropriate penalties, fines, and sanctions. We'll talk more about that when you come to the part of property practitioners. So in addition, the Act provides for a default position where parties do not have a building contract with clear terms on dispute resolution. We know that a relationship between a builder and a housing consumer commences from a home building contract, or the foundation rather, it's a home building contract. So dispute would normally arise. So it's critical that a home building contract that does provide for provision of how dispute will be resolved. But you do find that at times the home building contract does not, or it's not clear in terms of how dispute should be resolved. So the Act would provide that default provision, or rather that default position to provide for adjudication on contractual disputes. This is in terms of Section 55 to 58 of the Act. And currently, the NHBRC does not entertain contractual disputes. However, because we understand that our work, or rather contractual disputes, do impact on the relationship between the home builder and the housing consumer. The new Act does provide for the NHBRC to assist where it's necessary to facilitate contractual disputes between those parties. And lastly, the Act provides for alternative dispute resolution that will be in terms of Section 66 and 68 of the Act. And this part of ADR process would deal with any other decisions of the NHBRC staff, which does not include your non-compliances in relation to administrative or substantive non-compliance, and it does not include contractual dispute. So it will be any other decisions that would have been taken by the NHBRC staff. So in respect of the, in relation to quality control and the risk management that is brought by this new Act, the Act provides for a more enhanced disposition for how inspectors address non-compliances. As I've indicated in my previous slides, a register of enrollment, would detail the non-compliances that would have been identified during construction and how they are addressed. So it's critical that the responsible parties are held to account in respect of how they address such non-compliances. So the Act provides or includes the competence that inspectors must be competent. It includes their duties and their powers in terms of Section 69 to 71 of the Act. And in addition to the inspectors' accountability, the Act provides for a clear lines of accountability for various professionals in the built environment, more particularly, competent persons in the home building value chain, because they do play a critical part. Competent persons, these are your engineers, your structural engineers. I mean, once an architect would have drawn a plan and a plan is approved, you've got a structural engineer, who would design the structure that the builder must construct on site. So you can understand already that competent persons, they do play a critical role, because you find that some defects are not, or some structural defects are not necessarily as a result of a home builder having constructed the home, but you might find the home builder would have followed the designs of a structural engineer, but those designs might have, might cause structural defects. So the Act's intention is to bring all these critical parties, all those responsible parties to account in terms of the home building value chain. So in bringing these competent persons and certification bodies, this is meant to achieve, we intend to achieve this by ensuring that their duties are clear in terms of the NHBRC's Act or the NHBRC's mandate. The NHBRC is required to keep a register of competent persons and certification bodies as well. And it's critical that these persons hold a valid professional indemnity at all material times, as long as they appear on the list of the register of home builders, or register rather of competent persons. And this also applies to your certification bodies. So I've highlighted the relevant sections dealing with the accountability of competent persons and certification bodies as well. Maybe just to also give an example of how competent persons would account. I mean, having competent persons that would have designed the structure, if it is found that they have willfully or they've been grossly negligent, and they have failed to prevent a major structural defect on the basis of their designs, that kind of action or conduct would amount to a substantive non-compliance, which may trigger an administrative fine and other sanctions which may be imposed by the CEC. So I'll also highlight some of the responsibilities of a property practitioner in relation to the transgressions, as well as how the CEC may deal with any non-compliance by a property practitioner. So in respect of the warranty cover provided by the NHBRC, the new Act provides for an extended warranty. As I've said already, the warranty commences from the date of commencement of construction. This is outlined in terms of Section 40, subsection 1 of the Act, and the intention really is to widen the protection to housing consumers. In addition, the Act provides for an extended warranty for roof leaks. Currently, under the 1998 Act, it is 1 year warranty period. However, the new Act has extended that to 2 years. So this is in terms of Section 40, subsection 2 of the Act, and the intention is to widen the protection to housing consumers. And further, in relation to the maximum warranty amount, the Minister has been given the power to increase the maximum ceiling amount for claims against the warranty through the regulations. This is in terms of Section 40, subsection 3 and 4 of the Act. And the intention is to increase protection to housing consumers. So the regulations would be clear in terms of what would be the maximum warranty amount. Obligations imposed by Section 81, 82, and 83 of the Act. So the duties of property practitioners are outlined in terms of Section 81, which provides that before a property practitioner becomes involved in a sale of a home, they must determine if they're dealing with a home that has to be enrolled or is covered by the Home Warranty Fund. So that's one of the obligations of the property practitioners. And if the home is not enrolled, they must notify the NHBRC accordingly, inform the prospective buyer that the home is not enrolled, and inform the buyer of the consequences of that failure. So in the next slide, we'll deal with the consequences of failure to enroll a home and what it means to a housing consumer. So consequence of an unenrolled home, it would mean that no mandatory building inspections were performed by the NHBRC. I've already indicated when I was dealing with the register of enrollment, the importance of inspections. So there won't be a provision for the warranty. No statutory NHBRC warranty is available to cover any structural defects should they manifest. And the home may not be sold or transferred now or at any point in future. And the transaction may not go through based on obligations imposed to housing consumers and financial institutions as well. So dealing with the duty of financial institutions, this is provided for in terms of Section 82 of the Act. Financial institutions must, before approving a mortgage bond, application of financing, the building of a home, alterations or additions, determine if the home has to be enrolled or is covered by the home warranty. And if a home is not enrolled, the financial institution must notify the council and may not process any further payments in terms of the bond or other financing method before the home consent is enrolled. So in terms of Section 83, a conveyancer must, before finalizing the transfer of a home, determine whether the home has to be enrolled, and if the home is not enrolled, the conveyancer must immediately inform the council. So just to mention that these duties imposed on financial institutions and conveyancers are already provided for in terms of the 1998 Act. So the new Act actually just expands these duties and obligations to property practitioners. So failure by the property practitioner to comply with the Act, what does it mean? If the property practitioner fails to determine if a home that he's dealing with, it's a home that needs to be enrolled or is covered under the warranty and does not inform the prospective buyer and proceed, the NHBRC has two options available in terms of the Act. The NHBRC may report the property practitioner to the Property Practitioner Regulatory Authority in terms of Section 81, subsection 4 of the Act, or it may enforce Section 64 of the Act. Section 64 of the Act categorizes substantive non-compliances in terms of the Act, and these are more serious non-compliances, which means that non-compliance by a property practitioner to comply with the NHBRC Act is a serious transgression. It has been categorized as a substantive non-compliance in terms of Section 64, subsection 1D. So a substantive non-compliance may be investigated and a report issued in a form of a compliance notice. That is in terms of Section 64, subsection 3 to 4 of the Act. So once the property practitioner receives a compliance notice, obviously he would want to comply with that notice. Or the Act allows the property practitioner to object to the compliance notice. So if the property practitioner objects, he may object to the compliance notice through the Compliance and Enforcement Committee. Remember, I've already spoken about this statutory committee. So the property practitioner may object, and failure to comply with the notice or failure to object to the CEC. I mean, if you're given an opportunity to comply, you're also given an opportunity to object, and you fail to do that, the NHBRC may request the CEC to impose an administrative fine that can be $1 million. That's in terms of the Act, Section 64, subsection 7 of the Act. And however, the CEC may exercise its discretion on the amount to be imposed. It will not be necessary be $1 million. It could be lesser. So it is an offense to fail to comply with the compliance notice. or the decision of the CEC imposing a fine. It does not become an offense if you decide to take that decision of the CEC to a review, for a review rather, before a competent court. This is in terms of Section 75 of the Act. So how will the NHBRC assist property practitioners to comply with their obligations? I mean, as soon as a property practitioner learns that the property or the home that he's about to deal with has not been enrolled, what steps can they do? They know their obligation in terms of the Act, but the NHBRC must also, through its ICT reforms and updated regulations, provide clear guidance and digital support to meet, to enable the property practitioners to meet their statutory duties. Because you don't want to be in a position where you want to, report to the NHBRC that a property has not been enrolled, you are unable to access the NHBRC. So specifically, a dedicated compliance channel will enable practitioners to easily report unenrolled homes, ensuring all properties properly enrolled with the NHBRC. So I must say that the regulations would also provide clear guidance and, to ensure that property practitioners, they are properly guided in terms of their obligations in terms of the Act. And that brings me to the end of my presentation. Thank you, Naledi.
Thank you so much for the informative webinar. I am going to give access to the hands. I already see the questions. Thank you, Deli. Thank you, Nkadisha. Let me unmute Andres. Andres, please unmute and ask your questions to our speaker. Is your question to PPRA or NHBRC? Andres, you can unmute. Okay, let's go to Christine. Please unmute. I gave you access. Christine, I see your hand. Please unmute. Okay, well, they're trying to sort out to unmute. Let me go to the chat and see if we have questions there. My system is still loading. It's our technology. Okay, let me see. Okay, I have a question from Nicola, who says, are these for all homes or only new homes? And it looks like the question is for NHBRC. Our speakers.
Okay, thanks for the question. Okay, the Act is quite clear in terms of its application. Remember the NHBRC was established in by the 1998 Act. So meaning that new homes definitely are covered in terms of this Act. And when we talk about alterations and renovations, they are definitely covered in terms of this Act. So I'm just trying to emphasize that because the Act commenced in 1998, the mandate of the NHBRC continues, having commenced in 1998. I just want to give an example that the NHBRC would not provide any exemption for an exemption not to apply or to comply with the Act if there's a property that was supposed to be enrolled, let's say from 1999, and it has not been enrolled. So what is critical is that new homes are covered in terms of this act. Any renovations and alterations would definitely have to be covered in terms of this act. I hope I've answered your question. Thanks.
Thank you for that. I also have another question, also from NHBRC. You will guide me because I know you will be answering it as colleagues. I think you can jump in from NHBRC if you would like to take between the three of you. Does the NHBRC have a database of all properties enrolled with the council? If yes, how can we access it? And Kadisha, do you want to take this one or can we give it to Mr. Mbara?
Okay, let's give it to Mr. Mbara. Thanks.
Thank you, Chair. Good morning, colleagues. We do have that information. Yes, we definitely have a database of all homes that are enrolled, and our offices are able to provide that information in various provincial and satellite offices. But just going to what Ms. Rasuza was saying earlier on, we need to make this information to be readily available, especially in relation to the new obligations that are now placed on the property practitioner. So we should have a portal or something on the website where this information can be easily verified using whatever inputs may be most appropriate to the ERF number and so on. But currently you can get access to that information at our provincial offices. Thank you.
Thank you so much. I have a question going to the PPRA from Sanele. Greetings. Okay, it skipped again today, colleagues. Apologies. I don't know what's going on with the technology today. Let me go back again. I'll take Lehasa. I'll come back to that comment. Lehasa says to the PPRA, in a inter-property practitioner dispute, please clarify who pays the fee between two property practitioners. Which property practitioner would have to pay?
Thank you, Naledi. So the Act doesn't specifically say who should pay, but we are assuming that if a party wants to have the PPRA mediate a dispute, they would be the ones that would have to pay, unless they both consent to sharing the fee, then it would be in that way. But the Act just says any person who wants to have their issues mediated must pay a fee. So I'm assuming it's the person that initiates the request for a mediation, but parties can share if they want. So I think that's the only answer I have in respect to who pays.
Okay, I have another one while you're on the floor from Aisha. There is some agencies that their agents do not have a valid Fidelity Fund certificate. How can one report them anonymously?
Okay, thanks. And really, we appreciate those type of comments. So when you submit a complaint, if you look at our complaint form, it will ask you for your details. You have an opportunity on the section that requests for your details to just scratch it out and write anonymously. And that your details will then not be reflected when we then send that complaint to the property practitioner that you are reporting against. Another option, obviously, is when you then want to receive feedback, because we must give you feedback it becomes difficult for us to do that. You can then set up an email address where you're just specifically going to receive, that you set up for receiving feedback from us. Alternatively, you can call us and just find out what is the progress in relation to the matter. But yes, we also have a whistleblower line that is available. If you go on our website, you will find that there's a whistleblower line that you can submit your complaint through, or you can do the online complaint, but do not put your personal details so that the agent is not aware of who is complaining. So that's the way in which we protect whistleblowers, and that's the way in which we deal with whistleblower complaints. Thanks.
Thank you, Deli, for that. Gerard says, if a property should be registered and it's not, how do the owner get it registered and what are the costs involved? Do you see the email address I've pinned? Please send me the application form and the name you want to register. I will get someone in the FFC registration to help you with the registration process. My email address, it's pinned there. I have a question going to NHBRC from Mavis. I'll give it to Mr. Mbara. In terms of the enrolled houses, can we assume all bonded houses are enrolled?
Thank you. Yes, all bonded houses are supposed to be enrolled because in terms of the current legislation and even going forward in terms of the new act, financial institutions are not allowed to lend money registered against a mortgage bond unless the builder is registered and the home is enrolled with the NHBRC.
Okay, thank you for that one. Let's go back to the hands. Andres, please unmute. I gave you access and pose your question to the speakers. Andres? Okay, Christine? Please unmute. Michelle, please unmute. Okay, maybe they're struggling. If you're struggling to unmute, okay, you can ask the question. Okay, maybe it's also the issue of network. I'm going to go back to Nonhlanhla for PPRA question. I respectfully recommend that the penalties be suspended until an efficient and accessible system is in place. This would eliminate the delays currently experienced when accessing the required information through your offices and ensure that stakeholders are not unfairly penalized due to administrative constraints. The penalties imposed. Deli, do you want to take that one?
Is she talking about the penalties, the sanction imposed by the adjudicator?
Yeah, but I think it's also linked to compliance notices that we send out. I think she's implying that, for example, if our system would be working efficiently, then maybe the penalties would not have been imposed. So she's talking about maybe the registration issue linked to compliance notices, because also you mentioned in the slides that the matter can be adjudicated when there's penalties from compliance notices.
No, we can't suspend the operation of the act. We don't have the mandate to. But remember, when I presented, I said every party is given an opportunity to be heard. So if for some reason you are brought, let's make a practical example, you are charged with not having an FFC and you submit, because we give you an opportunity to respond, you submit to us and say, well, I applied for an FFC. There is proof that I applied for an FFC. The IMA department will assess the documentation that you have presented, will confirm with our registrations department whether this application was received. And if it's found that you do have an FFC, we then take the liberty to write back to the complainant to inform them of the fact that you did apply for an FFC. However, that FFC has been delayed and the prosecution or investigation will not proceed. So unfortunately, we cannot suspend the operation of the Act, because if we suspend penalties, then we're suspending the operation of the Act. But because you have an opportunity to be heard, or what we call the old alteram patem rule, then you will not be subjected to any adjudication, penalties, or disciplinary, whichever it may be.
Okay, thank you for that one. I'm going to go to Prudence, number 9. The reason for that is because she managed to unmute and others are struggling to unmute. I think everyone is affected by a network. I'm not sure why. Prudence.
Yes, good morning, colleagues. I just
Please.
want to double check how can it's the question is intended for PPRA. What protection does PPRA provide to practitioners? In this particular instance, it's for sectional title where we have a managing agent who is obviously registered with the PPRA, has a valid FFC, but whereby there's always frivolous complaints that are being made directly to PPRA by one of the owners, and obviously it's more of a personal thing. So if you have instances and we have a case that has been adjudicated by CISOs, but again now the weapon has become PPRA, whereby every 2 months there is a complaint that has been lodged against the managing agent to the PPRA. So in instances like that, what protection do those obviously I'm a property investor in my personal capacity, but it's like now PPRA has been weaponized. So what protection does that managing agent has against such instances where frivolous charges are being laid as a complaint, formal complaint?
So the investigation part of a complaint involves assessing the merits of the complaint. And where a consumer's issues have been resolved at CISOs and they fall within the jurisdiction of CISOs, even if PPRA gets them, PPRA will assess whether that issue relates to misconduct that we can handle. If it doesn't, we will inform the consumer. Even if we can lodge the complaint 6 or 10 times, we will not deal with it because we'll be able to specifically explain to him and dissect the issues that fall outside of our mandate, that fall within CISOs. And also, whereas if the issues have already been ventilated at the CISOs platform, there is no way that PPRA can also intervene. Even if CISOs has not ventilated them, as long as they fall within the purview and jurisdiction of CISOs, PPRA will not entertain them. So I'm not sure that I can say or answer and say this is the specific protection. We provide protection to every person who is wrongfully accused. So it's not only property practitioners, it is managing agents, it is every person who is wrongfully accused by a consumer. We will provide that protection. Our mandate is to act fairly and unbiased. It's not for us to prejudice property practitioners because the Act says that we protect consumer. We protect consumer, but we act fairly and not prejudice any party that is involved. Thanks.
So as a follow-up, does it not become a red flag then every time a particular practitioner, there are complaints lodged against that person from your side as well? Be it the same person or not, because I would worry in terms of my FFC, every time somebody, same person is lodging a complaint, as if it becomes a red flag to say, you know what, let's start, analyzing Prudence, because there's always complaints, are lodged against her as a practitioner, because we are also worried, obviously, in our personal capacity as property investors, even though we are practitioners in our professional fields. But it's like now we were getting worried this person might even lose their FFC because every time they're being pursued maliciously. So you don't look at those things. To your point, you look at merits irrespective of how many complaints are being lodged against that practitioner.
Yes, we look at merits. You can't apply an approach where you say you now red flag a consumer and say this consumer is always complaining against a particular property practitioner. We must look at the facts. That's what fairness entails. We must look at the facts, determine what facts are being brought to us. Even if he can bring the same facts 5 times, if there is no jurisdiction for us to entertain it, we will continue to decline it. Remember, we are a creature of statute. The statute that we work on does not say if a consumer lodges a complaint against a property practitioner 10 times, you must now not deal with that complaint. We can deal with it. And in particular, if it's the same issues, we will date our letter, which we dated previously, dealing with the issues, we'll date it on the date that we respond back to him. So it might be the same letter that he keeps getting, but we are not going to not look at it. And also, we are not out there to sniff property practitioners for anything. Remember, our responsibility is to protect, is an oversight. We're an oversight body. We must ensure a fair and balanced regulatory environment. It's very important. So property practitioners are important to us the same way as consumers are important. And the fact that a complaint is being lodged against you by a consumer does not mean that will now red flag you and keep following you, unless the consumer is reporting you for stealing funds. That one, we will even go out and inspect your books, and we can even get a court order prohibiting you from operating. But the initial or the start is for us to assess the issues that are being things. So don't worry about losing your FFC. Remember, if we comply with the act, and I said it before, I said clients always want us to make them happy. Yes, we should make them happy, but we should make them happy without compromising our professional standards and without compromising the right of us to earn a living or commission. So which means we must always do the right thing. If we do everything in compliance with the act and the code of conduct, when we then assess the issues, we will be able to determine if there is misconduct or not.
Thank you so much. That helps.
Thank you, Deli, for that one. Let's go to Michelle. Please unmute. Michelle? Okay, Brenda? Brenda, please unmute and ask. Okay, Jean? Jean, please unmute and ask. Okay, let's go to BSU. BSU?
Good day. Can you hear me?
Yes, please ask your question.
Okay, so I got actually 2 questions. First question is, according to PPRA regulations, it's 14 days to get once a complaint is logged. But we got, actually, I'm from KZN, and we've been have people that are complaining that for over 2 years, some is even over longer than that, where they log complaints online and they don't have any feedback. They have actually emailed Tato with regards to this year. Tato has informed clearance to actually handle this, and clearance got no, hasn't provided us feedback. What do we do then? And my second question is, with regards to dispute resolution, where do you, we had a case where a case manager withdrew cases against a property practitioner who had no valid FFC. At adjudication process, the company states straight that the guy has an estate agency license, but was practicing as a managing agent. And when we brought, after the case manager withdrew the case, when we asked the question to the case manager, how did she withdraw the case? Was there an application or anything that she was provided as evidence? She has no answer. The case, she tells us we must follow the review process. And then when we log a case with the public protector against PPRA for this year for failing in the mandate, that's when the case gets reinstated. How is this a fair process? Because this actually brings down the property practitioner's regulatory name and actually is actually a disgrace.
Thank you, Naledi. I'll start with the complaints for over 2 years, and I should rightfully state that I know who is complaining. I myself have received your emails. From the emails that I have received, we have responded to all of those complainants who have complained. And some of those complaints have been closed. And also what we noticed is that it's the same complaint, but it's being submitted by different people, because this is a matter in which people in a body corporate are unhappy. And at one point it was submitted by one person, then it was split, everyone submitted their own. But just to close that response is to say, if there are still other complaints that have not been responded to, I'm happy to intervene. And I know that Clarence would have done that, but if you insist that they are still, send me an email and please put a list of all those consumers together with their ID number so that I can provide a comprehensive response. And then when we come back next time here, we are not dealing with the same issues. I'm willing to help and I will do that. Please, can we work together so that I can also make sure that those consumers are assisted, because we are here to protect the consumer. And then the second question, I know about your case. And I think there were a number of property practitioners that from that same managing agency where there was a complaint that they were not registered. We then, the legal officer investigating, then did an investigation and evidence was submitted. We can give it to you. I also saw it when she brought it to my review, that the managing agents were registered and had Fidelity Fund certificate. However, you are correct. There was one in particular that did not have an FFC. And that matter has now been reopened in respect of that one property practitioner who she later found out her documents her FFC had only been obtained after the transaction that was complained. He had an FFC, but that FFC was after the transaction, which means he or she should have been charged, because at the point of transacting, there was no FFC. We've reopened that, and I can acknowledge that that error was done, but we've rectified it. We've opened the case and that matter is proceeding. And your legal officer, I did see the letter, wrote back to you to inform you that the process is proceeding. I'm not particularly sure that you are telling the truth that it went to the public protector, because it was immediately after the hearing. When you then sent to her and engaged her, she then reopened it, unless I don't have my facts correct. But we are dealing with your matter and we will definitely deal with that property practitioner. Thank you.
Thank you for that. Antoinette, please unmute and ask your question. Thank you, Deli, for answer. Antoinette? Okay, I'll move to Sibonelo. Sibonelo? Okay, if you don't ask, I'm going to lower your hand so we allow other people. Andrew, you already unmuted. Please ask your question.
Morning, good morning. Yes, it's Andrew. Yes,
sorry, Andrew.
Andrew.
Sorry, Andrew. I think Sibonelo managed to unmute. Let's allow him. Apologies, Andrew, for that. Maybe there's a delay on their side. Sibonelo, you can continue with your question.
Oh, yes. Morning to everyone. Naledi, I wanted to ask Kuba, is it possible to get this presentation through live or else YouTube link, if I may ask for that? And then also, my second question is, when the OPD5, how to continue about, since we have OPD4? Yeah.
Oh, okay. So the slides we are going to share with everyone who attended the meeting. I'll email everyone. It's usually what we do every webinar. And the recorder, we post it on our PPRA TV on YouTube. Maybe follow us so that you can access all the recordings. We're going to share it because today is a Friday, Saturday, Sunday, maybe Monday. Can I promise that Monday we would have posted that link there with the recorder, but the slides I will send you today. And regarding PDE 5, remember you need to do NQF 4, then write your PDE 4. Then after that, you need to do your NQF 5, then write your PDE 5. So I don't know, do you have NQF 4 and 5? Sibonelo?
Ingakho sesingibuza so
Oh, yes,
ingakho
bengithi
ngibuza and then
uyangizwa, angithi fanele ukuthi uyenze i-NQF 4 yakho, then uyenze i-NQF 5 yakho. Then after that, nakhona you'll have to do your PDE 5, but also fanele ukuthi siyazi ukuthi which status do you have as a principal. Remember, you start as a candidate, then you do your NQF 4, your PDE 4, you upgrade to full status, what we call non-principalization. Then you have to become a principal, that's your NQF 5 of PDE 5. And if you have qualifications, they can also exempt you for that. But what I'll do as well, I've pinned my email address because there's no education team in this webinar. Let's assist you offline. Ngakusiza offline. Never. We have an email address on the chat. Okay. Daily, I saw your hand. Do you want to?
Email. I will just email it to you.
Okay, Nyabonga. Daily, I saw your hand.
No, I think Naledi, you've answered the question. Bengithi ngizomlekelela ku answer that question, but you've answered it.
Okay, thanks. Andrew, sorry about that. You can come and continue your question.
Thank you so much. It's Andrew from Wirend Properties here in Ekurhuleni. Yes, I think I will ask one or two questions on the NHBRC. Can I go back about 10, 15 years ago? The municipalities, especially Ekurhuleni, when you submit your building plan, they also requested your enrollment with NHBRC. But all of a sudden, it was no longer a matter for the building inspectors to ask for the enrollment of the NHBRC. On that, I wanted to know if the government departments could not work together, because obviously with that, there was no more a reason if the building inspectors would monitor that as a government department. But for now, it's like the NHBRC is taking this duty and outsource it to the PPRA, to the property professionals, to say, you guys, you have got to monitor this. So yeah, my question, it will still remain, could the government departments not work together in order to get this in line? That is the first question. As a property practitioner, if I am selling a house which was enrolled 20 years ago, which was a 40 square meter house, obviously it was enrolled 20 years ago. Then maybe 5-10 years later, one wing was extended. It was there was another added wing to make it a 70 square meter house. Then 3 years ago, another 30-40 square meters was. So in total now is now 120 square meter house, or 150, but it was a 40 square meter. NHBRC, are you happy because it was enrolled? And these guys, obviously they were doing it, the property owners, they were doing it on cash basis. There was no reason, because as I am saying, the municipality didn't, even today, they don't require the NHBRC in order for them to process your plan when you submit. So should I then say this property is enrolled? Should I be happy as a property practitioner? Thank you so much.
Thank you, Mr. Mbara.
Okay, thank you. I think I'll start with the last question. about a home which was enrolled originally. As you know, currently we do not cover alterations and additions, which means that if a home was enrolled originally and then it was extended, that original enrollment would be sufficient for purposes of your obligations in terms of the new act. We would not have expected that the home would there would be no need for enrollment of the structures which were added after the original structure, because the additional structures did not fall under the mandate of the NHBRC at the time that was done. But if that scenario were to happen after the new act comes into operation and additions and alterations are required to be enrolled, it means the home would have been enrolled initially as a 3 or 4 bedroom, and then you add other structures, and if the requirement is that the additions and alterations must be enrolled, you would then be expected to have the necessary compliance for the additional structures that were put in place. The question of the NHBRC versus the municipality and arrangements that were in place at some point, we continue to work with different municipalities to assist one another to ensure that there is compliance with our respective mandates. So we continue to engage with the municipalities on that issue. And there are several municipalities where we have a memorandum of understanding in terms of that. So the Ekurhuleni municipality that you have mentioned, it's we have taken note of that. We have taken note of that. So we will be continue to engage different municipalities to strengthen compliance by making sure that we collaborate where possible to ensure that homes that are, when there is an application for plans, there is a way to comply with our mandate. The only challenge is that, which I suppose is the biggest impediment to this collaboration, is that, remember, when you enroll with the NHBRC, you need to already have the approved plans. So you would not be able to get enrollment of a home when you submit an application for plans at the municipality. The plans would come first, and then once you have the plans, then you are able to enroll. So I suppose probably that is where the challenge is, because you have to start with the plans, because when you come to us, we want to see the plans. So you would not be able to enroll before you can actually have the plans. And the approach we had taken was that once the plans are approved, in terms of the collaborations we have with the municipality, once the plans are approved, when the building control officers go to site to do part of the work that they're expected to do, they should be able to share that information with us, so that we ensure that if the home was not enrolled, they are then able, the builder is then compelled to enroll the home. Thank you.
Thank you, sir, for that. Let's go to Lorraine. Please unmute and ask your question. Lorraine? Okay, Percival? I'll come back
Good
to you.
morning.
Thank you. Please ask.
Yes, can you hear me?
Yes.
Yes, Naledi, just a quick one directed to you, Naledi. I've been trying to reach you with regards to me being excluded from, my firm being excluded from the incubation program. However, I'm thinking that it might have been because of the minor, the minor compliance issue that we had last year. Here's my situation, and I'm directing to you, Delhi. Here's my situation. In 2023, I did apply to be exempted from operating a trust account. That was 2023. All documents were submitted, except one document that was the letter from the bank to say that the trust account had been closed. It couldn't because there was also a dispute between myself and the bank by then. However, the matter was resolved via the office of the NFO, the Financial Ombud. And it was also found out the bank were supposed to have issued the letter to me immediately because I didn't have any outstanding amounts that was charged by the bank illegally to me. So what I want to find out from you, what is the position currently? Does that mean that seeing that the bank have resolved that matter and all documents were even submitted, will I still be having to be charged penalty for not having applied for exemption for holding the trust account in 2023? Will that apply retrospectively, seeing that it was not my mistake, but was the bank mistake, having to also involve the NFO to resolve the matter? Thank you.
Okay, because you asked two questions regarding incubation, that's transformation. If you have applied before, as long as the documents are compliant, opportunities are given to everyone. I don't think they would decline access for you to participate. You can also be a host employer if you're a principal. So regarding
Yes.
section, oh, you want to come in?
Yes. Yes, I am a principal. I did apply. It was declined, but I'm thinking it might have been because of the issue with that minor compliance issue. But currently, I'm not even sure what the status is, because whether that issue was let alone, seeing that it was not my fault that I didn't get the letter from the bank by then, but even though it was corrected at the latter stage. So please, I'm going to try to reach you again and give you the details with regard to the incubation.
Yeah, but you for incubation, you can't reach us because you have to wait when we advertise. Remember, we advertise every year because we cannot say we give it to this person. There's a panel and a committee that sits and they have to assess all the application. If you're compliant, you don't have past convictions, you have FFC, you have worked for more than 12 months, body of work, your profile of the company, because they look at all, if you completed the applications correctly. If you applied on time. A lot of people, I saw that they applied later and it already applications were closed. So every year in October, November, they do advertise. I think you can apply again for this year, but you are quite right that you have to fix other issues of compliance. So maybe send me an email. I'll send it to Thomas Magupo and Dineo Mpahlele in the audit department. They can help you to be exempted because they have to look at the system and see if you don't owe anything regarding your audit submission, because you must submit your winding ups, auditors reports, and that bank letter. So they would need to look at the system. What is it that you are owing, or if you're not owing, and if they will approve you to be exempted. So they will assist. My email is there. I pinned it. Maybe send me the document so that we get all the issues of compliance, so that when you apply going forward for incubation or to be part of SMME, we know that your profile is good standing, then you can stand a good chance, if you do qualify for that. Will that work for you, Percival?
Thank you very much, Naledi. Yes, I will make a follow-up.
Okay.
Yeah, I will make a follow-up.
All right, thank you, sir. Monica, please ask.
Naledi, I think he had posed a question. Yeah.
Oh, come through, Delhi. Sorry.
Sorry, no, that's fine. So With respect to the exemption that you did in 2023, because it was not granted, then you will still be liable for penalties, because what was supposed to happen is that if you had an application that was non-compliant, the Act says we can assist. And the issues also do not reside. We hear it was not your fault, but it was also not the PPRA's fault. And definitely the Act says you must then submit your audit report. So what you are supposed to do while you are resolving the issues with the bank is to continue to comply with the relevant section of the Act, because that relevant section of the Act requires you to submit your audit reports while you are trying to close the account. So yes, you will definitely be liable, and that 2023 application was non-compliant, so there is no way we can backdate an exemption, and the Act is clear. Any exemption cannot be backdated. It is granted at the point of compliance and application.
Thank you, Deli, for that. Can I move to Monica?
Thank you, Naledi. So my question is regarding the managing agent FFC. As if you are just a property practitioner who want to pursue this FFC, I just need to understand what exactly are the requirements with regards to the E1 exemption. Do I require to be a principal prior applying, or as a normal property practitioner who hold a valid FFC? Is this an FFC that I can pursue?
Deli, do you want to try to answer that one, or can I allocate it to exemption team? Oh, come through, Deli.
Yeah, I'll try and assist. So I'm not sure if I got her question, but are you speaking about having two FFCs, one as an agent and one as a managing agent? And is that your question?
Yes, currently I do hold a property practitioner FFC, but I
Okay.
want to also pursue the managing agent FFC, so which means I want to have those two FFC. So
Yes.
it's just to get a clarity on the requirement exactly regarding that E1 exemption.
Okay, so you are required to have FFC. So the managing agents, if you want, I know that managing agents, they don't have the same what do you call the same not qualification, but they don't categorize themselves as principal and candidate. So you will need to then apply to the PPRA, and they will let you know what is required of a managing agent. But I think the rules are much relaxed because of the current educational regulations. I'm just not really sure or what are the requirements, but I know that you really do need two FFCs.
Okay.
Yeah.
So should I take
You
this
can email me. I'll
exemptions
send.
department?
Yeah, email me. I'll ask somebody in the exemptions unit to give you a call.
Thank you, Naledi. We'll do that. Thank you.
Thanks. I have a question on the chat speakers from Kenneth. Will the PPRA update the immovable property condition report to include the required questionnaire in relation to the new NHBRC Act? Please mute yourself. Let me continue with the question. Okay, sorry, colleagues. Let me see who's not unmuted. Andrew, I'm going to disable your mic. Apologies about that. Let me find the question for Kenneth.
No, lady, I think I get it. It's something that I had also made note. I think he's talking about the mandatory disclosure form, and I had made notes to say that it will then be important for the PPRA to update the mandatory disclosure form so that it includes a question to the seller around the enrollment of the property with NHBRC. But what we should also remember is that the mandatory disclosure form is in relation to the seller who must then, if we include it in the mandatory disclosure form, confirm that the property has been enrolled. And also maybe the question would then be, supply a copy of the enrollment. Remember, however, the NHBRC has made it clear that the estate agent has an obligation to verify that the enrollment of that property is there, because we do know that a seller can confirm that it's there. When you then go to the NHBRC, it is not there. So it will be included as part of the mandatory disclosure form, but it doesn't take away the requirement for you as a property practitioner to also do your verification or to go to NHBRC and such, because that's how I understood the provision of the act, to say you as the property practitioner are also supposed to do it. That is why there is penalties or contraventions for both the homeowner as well as the property practitioner. So we'll try and accommodate and update the mandatory disclosure form, but also maybe we can also have a section that then asks the property practitioner if they've verified that the home has been enrolled. But yeah, we'll try and work around it. It is something that I had made note, and thank you also for then bringing it up.
Thank you, Deli. Then he further says, I think maybe let me allow Mr. Mhlongo maybe to also comment on that, because he further says, or will the NHBRC supply the questionnaire which can provide to the seller to complete when taking a mandate? Mr. Mhlongo, do you maybe also want to comment on that one following Deli's comment?
Chair, thank you, but I didn't get the questions. Just heard something here, but you were asking the questionnaire which will be provided to the seller.
Yes, the question was coming from Kenneth, where he was asking if PPRA will work with NHBRC. Remember on when they have to check if inspections were done. Then on the question he says, or will the NHBRC supply the questionnaire which can be provided to the seller to complete when taking a mandate when they're selling?
Yeah, I think that would be also something to consider. But one of the things I think which at the end we want to do is that basically we will have a collaboration with the PPRA in terms of that there will be a coordination. But I will also like to give it to my colleague, because I've got some question which I wanted to ask to PPRA, so I couldn't be recognized. But this I will need my colleague and NK to add. But I think that will be also advisable, something to consider as we go along with our new legislation. NK.
Yes, Naledi, if I may. In actual fact, we discussed this. Unfortunately, Mr. Mhlongo was not there, but he's correct that we'll have to collaborate with the PPRA. In actual fact, our thinking was what Delhi has indicated, that if PPRA would amend their mandatory disclosure form, I think that would be first prize for us as the NHBRC. But obviously noting the obligations that is imposed on the property practitioners to verify with the NHBRC that indeed the home is enrolled. But we do support the proposal by Delhi. Thank you.
Oh, thank you so much. Mr. Mhlongo, you may ask your question.
Okay, thank you, Chair. My question was on the PPRA adjudication process. In fact, I wanted to check the independence or partiality of the process. For example, I saw somewhere that there are 3 qualified personnel who are dealing with adjudication process. Like in our case, we normally have a panel for DC processes. who are actually not employed within the organization. So I wanted to check these 3 qualified personnel, they are actually permanent employed at the organization there, or they are just selected, or they are. So how is that process entailing selecting them, or do you just get selected as and when there's a new matters? So that just wanted to check that with I think the presenter at the beginning. Thank you.
So I'm not sure, but here's my answer. So at adjudication, we have an adjudicator, but we also have, in terms of the old act, a disciplinary committee. So currently we have matters that fall under the old act. Under the old act, there is 3 people that form part of the committee, and this would be 2 committee members plus the chairperson. The qualification of the committee members is industry players, so it's not PPRA. It's industry players, which means it's estate agent. The chairperson is a qualified attorney or advocate, independently appointed, and the independent appointment of all of these 3 is that the process that we follow is that every 3 years we issue out a tender and appoint committee members and adjudicators who then sit in this hearing. So we have a panel, and when we have hearings, we go back to the appointed panel and we select an adjudicator if we need an adjudicator. And if we need a chairperson and committee members, we select from that panel, which was appointed through a tender process. So they are not employed by the PPRA. They've never worked for the PPRA. The PPRA in-house has attorneys. These attorneys are the investigating officers and case presenters. Theirs is to investigate and present the case. The adjudication and the disciplinary committee is an independent panel appointed through a tender process. Thanks.
Thank you, Deli, for that answer. Maybe I'll allow an extra 6 minutes before we close. I know it's 12 o'clock. I'll take the last 3 questions from the chat because, this is part of our awareness. Let's not disadvantage those who are here to learn. If it's okay with you, speakers, because I don't want to hold you up for too long. I have a question coming up from Gabetsu for PPRA. Can the PPRA help in a case whereby a former principal did not pay commission to a property practitioner and is not replying to communication efforts? Daily for that one.
Naledi, I think I responded. Yeah, but I when I was explaining interagent disputes and mediation, and I said that the mediation process comes in where we have to deliberate disputes between property practitioner, especially where there's a commission dispute, then mediation can be done for inter-property practitioner disputes at a fee. So yes, we can. You just need to be able to lodge the complaint and tell us you would like us to engage in the mediation. Then we'll tell you how much you have to pay. And if you're amenable, we'll then assist.
Okay, I have a question coming from Buitumelo. I'll allow PPRA to take it, then Mr. Mbara will come after. She says, or he says, will the homeowners in South Africa be notified about this new law if a seller was not aware of this and immediately enroll the how? With the grammar, I'm not sure what she was trying to say. Enroll the... How is there a waiting period required before they can sell the house? Okay, I think it's for NHBRC, Mr. Mbara. I hope I read it well, Buitumelo. I couldn't... Let me allow Mr. Mbara, if you understood it, because I struggled a bit with what was she saying there? If you want me to repeat it, the question.
Please just repeat the question.
She says, will the homeowners in South Africa be notified about this new law? If a seller was not aware of this and immediately enroll, okay, this is where I got stuck as well. But Buitumelo, if you want to come in, please raise your hand. And then she further says, is there a waiting period required before they can sell the house? Do you understand it, sir?
All right. Okay. Yes, I think I get the gist of the question. Yes, housing consumers will be made aware of the new act. Our marketing and communication section has got various programs that are intended to make sure that we take message to the public out there so that they know what is expected of them, and they also know how the new law will benefit them. On the issue of enrollment, the requirement for enrollment it's something that has got to be done. The home has got to be enrolled. So we sometimes have queries from members of the public or other persons asking whether they can now sell this home because the home is now outside the warranty period, which is the 5-year period. So there is no way of escaping the compliance with the act. So the home has got to be enrolled even after 5 years or 10 years. If the home was not enrolled, it means that it does not comply with the legislative framework. And it means that the obligations to report that non-enrollment, the non-enrollment of that home to the NHBRC stands, and also informing the potential buyer about the consequences of the fact that the home is not enrolled with the NHBRC. So there is no waiting period. There is no waiting period. The only thing is that insofar as the obligation of the property practitioner is concerned in terms of the new act, theirs is to report that to us, is to verify, and if there is no enrollment, report that to us, and to inform the purchaser of the fact that the home is not enrolled and the consequences of such of the failure to enroll the home. Then they can proceed with the transaction. As
Thank
long
you.
as they have done the obligations in terms of what is expected of them, then they can continue with the transaction.
Thank you, sir, for the answer. Daily Bafana says, can X and Y in dispute appoint a private mediator supervised by PPRA?
No.
Okay, thank you for that. Unati, you can unmute and ask your question. Unati? Okay, I'm going to go to the last question and we will close the webinar. It comes from Andres. Kindly advise with regard to NHBRC enrollment related, or rather the lack thereof, of agricultural small holdings that used to be under, say, peri-urban control, and there's no building plans. Right or wrongly for that matter, as for most of such structures will mostly probably be able to get approved plans. I think it ends there. Ms. Nkadisha Rasabodza.
Thanks for the question. Based on the collaborations that NHBRC has with municipalities, we do acknowledge areas where you find that it's difficult for the municipality to approve plans. Most probably that you might find that certain issues like town establishment has not been approved. The necessary approvals have not been obtained in respect of the area, and it becomes difficult to have an approved plan. But based on our collaboration with the municipality and policies that are being established within the NHPRC, acknowledging the depth of this kind of matters, we do accommodate certain approvals from the municipality to confirm whether they provisionally approve the plans, because plans have to be there even though they may not be approved. So based on those collaborations, the NHPRC is providing enabling provisions to engage with municipalities to ensure that at the end of the day, we assist housing consumers and we are able to enroll those homes, and warranties it's provided. It normally happens in your provinces like Limpopo, where you find that there are, big houses that are being constructed in your rural areas, and the Limpopo province. I mean, our office in Limpopo is able to negotiate with your ndunas and the hoshi to ensure that there's necessary approval that is being obtained to enable compliance with the NHPRC. These are matters that are being considered by the NHPRC. Thank you.
Thank you for that answer. And I think it will also answer this question from Albert, who says, a question to NHBRC, is it possible for a registered company to NHBRC build a property at tribal site without approved plans? But I heard that you were touching on the Induna part, but do you also want to comment on that, Ms. Rasabota?
The thing is, I think it's the same answer that I would provide, but what is critical is that we have to bring the relevant parties to the party, your municipality, and your leaders from the tribal lands to ensure that there's consensus in terms of the obligations of the municipality, the obligations of the NHPRC as well. So as the NHPRC, we don't just accept without collaboration from the municipalities and the tribal leaders. Thanks.
Okay, and those who are asking for contact details for NHBRC, because I'm going to share slides with you, there's contact details as well. You will find them on the slides. And I'm going to take the last two hands and then we can close. Unati, please unmute and ask your question. Unati?
Thank you very much, ma'am. Greetings to everyone who has attended the session. My question is directed to PPRA specifically. Can you hear me, ma'am?
Yes, sir, we can hear you.
My question is directed to PPRA specifically. With regards to the issue of the managing agents, we deal with a lot of those managing agents. Some of them, they sometimes get involved in unethical conduct and failure to maintain the professional code of ethics in terms of performing their duties, and money is missing, maybe ill-advising the trustees in the sessional title scheme. I'm just want to ask from PPRA perspective, how does PPRA hold these managing agents accountable? Thank you very much.
Okay, hold on, Ms. Nkambule. Let me take the last questions we'll answer, and then that will be our last answers. Ms. Nomvelo, please unmute. I gave you access. Please ask your question.
Okay. All right, thank you so much. And my question is also directed to PPRA, but it's a bit out of what we are talking about today. So I just want to find out if a person recently registered a firm, a real estate firm or estate agency whatsoever, do they also need to register the company with PPRA, or
they register a firm and a company.
Yes.
Okay, I don't understand. Is it not the same thing? But let me allow Daily. Let's try to answer. And the ones that are not related to today's topics, I will send all the questions and queries to the right departments that will provide answers. Daily, we can start with Unati. How do we hold managing agents accountable?
Naledi, can I just start quickly with that one? So
Yes.
all property practitioner firms are supposed to be registered. So if you've opened a firm and you must have it registered with the PPRA before you can operate that firm. The only thing that happens now is that the firm is not paying for the FFC, but you must have it registered with the PPRA, because if it's not registered, then it means you'll be operating illegally. Further to Unati, so I took you through the investigations process. If you have a complaint with against a managing agent because they fall under one of the people of the categories that we regulate, then you submit a complaint. We will assess whether we've got jurisdiction. We will assess whether we've got jurisdiction to entertain the complaint. In particular, what you are complaining about. If it involves unethical conduct, contravening our act or code of conduct, we will definitely take that managing agent through the entire investigative process up until we get to adjudication. Even in terms of misappropriation of funds, we will do that. However, if those funds were sitting in the managing agent's trust account open in terms of the Property Practitioners Act, if those funds are sitting in the trust account of the body corporate or HOA, we will discipline the agent, but we will not be liable for a claim against the fund for monies that were sitting in a body corporate or HOA account. If the money was sitting in a fund, in a trust account under the PPA, then we will also, over and above the fact that we discipline and take the agent to adjudication, we'll also consider whether those funds can be considered by the claims department for reimbursement.
Thank you, Daly, for those answers. Before we close, can I allow Ms. Rasebotsa maybe closing remarks before we close the webinar?
Thank you, Naledi. Well, I want to thank everyone who has attended and made time to attend this webinar. And also acknowledging that if one has to navigate regulatory changes, sometimes it can be challenging. But staying informed is quite critical, and it's obviously the first step to ensure a successful compliance. I hope everyone had a fruitful session. The NHPRC would be finalizing the regulations and rules and will be available for further engagements in future. Thank you.
Thank you, ma'am, for that. Ms. Nkambule, do you want to maybe emphasize on takeaways?
Just to say thank you to all the colleagues that attended the presentation. We really appreciate your attendance. We hope that we've been able to give some light as to our adjudications process. We are also available for any further information that you may need. Please also note that when we send our emails, we are also availing ourselves for any issue that you might face with the PPRA, and just not only on the processes that we've laid down today. If we're unable to resolve the matter or it doesn't sit within our space, we will definitely then help you to escalate it to the relevant people. So thank you, colleagues, and we appreciate your support all the time. Thank you, Naledi, and to NHB colleagues, thank you. Look forward to working together.
Thank you, Daly, for that. We want to appreciate Ms. Rasebotsa, Ms. Nkambule, Ms. Tambara, Mr. Mhlongo, and everyone who participated who participated in the session. And colleagues, we encourage you to apply everything that you've learned today from PPRA section 28 to 30, from the mandate and why the act of NHBRC is important. You saw the warranty cover they touched on, and you can share also the slides I'm going to share with you with those who couldn't attend. The recorder is going to be on PPRA TV. You can access it. It's for educational purposes and for awareness. It's not for CPD, the session. As I've mentioned, that we are legislated by section 69 to make sure that we bring you educational topics to empower you, and we make sure that you stay compliant. If you have questions, like Daly mentioned, please, my email address is on the pin chat. I don't know if Ms. Rasabota, you want to share your email address on the chat. Somebody was asking me for your email address, but I told them to email me and I'll forward them your email address. But if you don't mind to put it on the chat, maybe we can share if they want to be in contact with you for more questions. And we wish everyone a productive day. I know we have passed with 20 minutes. We had promised that we'll finish at 12, but it was important that we address all of the questions. We look forward to welcoming you on the next PPRA webinar. Next week, we won't have a webinar, but after that, on the 30th, we're going to discuss claims processes, and we're discussing with the rental tribunal will be in our webinar so that we can engage them further. I will share the link, I'll share the slides. Any communication, please follow us on social media so that you don't miss anything. Colleagues, stay compliant, stay informed, and let's protect consumers. Thank you so much, and goodbye. Drive safe. Enjoy your lunch. Bye, colleagues.
Bye-bye. Bye-bye.
Thank you.
Bye.